This episode of AHLA's Speaking of Health Law is sponsored by HMS Valuation Partners. For more information, visit hmsvalue.com.
Welcome to today's AHLA Speaking of Health Law podcast. I'm Don Crawford, partner with HMS Valuation Partners, and I'll be your host for today's episode. We've got a fast-moving, high-impact conversation lined up for you. Today's episode is entitled Pathology Under the Microscope, Fraud and Abuse Risks, What Attorneys Need to Know. We'll be breaking down everyday arrangements pathology groups rely on, hospital service arrangements, TCPC structures, acquisitions, and why these routine deals are getting so much attention from regulators. We'll talk about where the pressure points really are, what the DOJ and OIG are zeroing in on, and how counsel can navigate these arrangements without stepping into avoidable risk. But hey, before we get started, let's kick things off with some introductions. We've got three fantastic guests with us who live this work every day. Would each of you share a bit about your background and your focus of your practice? Lisa, let's start with you.
Hi, my name is Lisa Ray. I am a partner with Arnold & Porter. I joined the firm last fall after a 20-year career at HHS OIG, and I take that experience to help counsel clients on fraud and compliance matters. Thanks for having me with you today.
Danielle?
Thanks, Don. Hi, everyone. My name is Danielle Tangor. I'm a partner at Robinson & Cole, and I have a national pathology and clinical laboratory practice along with other healthcare providers counseling on regulatory fraud and abuse and internal investigations, and look forward to the conversation today. Thanks to HLA for having us and HMS for inviting me.
Great. And Liz?
Thanks. Hi, I'm Liz Sullivan. I am a healthcare attorney with McDonald Hopkins. I head up our healthcare practice group. I started my career at McDonald Hopkins. I also spent a number of years, about 5 years in-house with a large academic medical center. And I've been back at McDonald Hopkins for about 10 years. And my practice is also focused in pathology and clinical lab. And really, although it's not exclusive to that, I also am very focused on business arrangements and fraud and abuse compliance, billing issues, sort of anything that might come up for a healthcare provider, but particularly for physician groups and independent providers. So I'm very grateful to be here today and looking forward to this discussion.
Great. All right. Well, thanks, everyone. Well, look, let's start with hospital professional service agreements. Every pathology group has them, and hospitals are tightening budgets. That pressure can somehow change how the agreements are negotiated and sometimes how they're even structured. So what does that mean in practice? And what's the government drawing attention to right now? Lisa, can you kick us off?
Sure. So to level set, I want to start this conversation really with a common understanding of the anti-kickback statute. The kickback statute is a criminal law that prohibits paying or receiving remuneration, which really means anything of value, to induce referrals for items or services that can be paid for by federal healthcare programs like Medicare and Medicaid. It's an intent-based standard. It is very broadly written and interpreted by the federal government. And it's important to remember that arrangements raise kickback concerns if just one purpose of the reason for the agreement is to generate federal referrals. So with that background, OIG has created a lot, given those kickback statutes, given its breadth, OIG has created regulatory safe harbors for certain situations which can protect business arrangements. You can comply with those voluntarily. If you don't satisfy each element of the safe harbor, it doesn't necessarily mean that it violates the law, but the more protection, the more you're within the safe harbor, the better protection that you have. So with that said, HHS OIG has warned about financial relationships between hospitals and doctors since at least 1991 in terms of their published guidance. And their concern is pretty straightforward. If a hospital pays a doctor more or less than fair market value, or requires the doctor to pay the hospital more or less than fair market value, then that financial imbalance can implicate the kickback statute. The general rule is that remuneration flowing between hospital and doctor has to reflect fair market value for services that are actually performed and that they are structured at an arm's length transaction. Really, the government has concerns. They really look for, something that they would, looks like a sweetheart deal. So trying to make sure that the relationship is, that arm's length transaction. This is particularly relevant for traditional hospital-based doctors like anesthesiologists or radiologists, and of course here, most importantly, pathologists. And that's because the concerns are different where the hospital makes the referral or where the doctor's making the referral. And in this situation with pathologists, the hospitals are often the ones that are in the position to influence the flow of business that's going to go to the doctor. So OIG looks at the relationship holistically, doesn't just focus on one piece of the arrangement, but really evaluates over the arrangement overall, including like exclusivity provisions and service exceptions. And then we want to make sure that it truly reflects fair market value, given all the facts and circumstances and the arrangements between the parties. OIG has given a lot of guidance, most recently in the General Compliance Program guidance, and it provides a series of questions that you can go through when you're trying to assess fair market value.
Okay, well, great. Well, thank you for that. That's a great framework. In real world contracting, where do pathology groups actually hit the toughest negotiation friction? Are there certain expectations for included or informal services? Danielle, Liz, can you all take that?
So I guess kind of to describe the arrangement, and this may be typical for other specialties or hospital-based specialties, but there's typically sort of two parts to the arrangement loosely. This obviously is kind of an overgeneralization, but you have the professional services that the group will perform, and that's, the business that is directed from the hospital, typically under an exclusive arrangement. And so the group will perform those professional interpretations, bill directly for those. Typically, the group is also going to be contracted under that professional services agreement to provide medical direction, maybe for the pathology department if it's organized as a department, but for sure, I won't say for sure, but in most instances, also for the laboratory. They are going to be the laboratory director of record for the CLIA certified laboratory for the health system, and they're going to be responsible for the duties that go along with that. And so for the professional component, straightforward, that's typically going to be billed by the group. But the hospital will often reimburse the group for the work that they're doing for the medical directorship, oversight of the lab, and maybe some other things as well. And I think with sort of the downward pressure that exists in budgeting right now, there's sort of two ways that I would say I see it playing out. And Danielle, I'm very interested to hear your perspective, but one is just on the reimbursement for those professional oversight services, medical director services, sometimes called Part A services, because there is some reimbursement from Medicare Part A for the hospital's overhead, which includes, that oversight piece. Those Part A services, we're seeing downward pressure, whether it's reimbursement on hourly rate, reduction in sort of a larger set fee, or a cap on hours. So the hourly rate itself isn't the issue, but the hospital administration is, asking for reduced hours or capping the hours somewhere that they feel is appropriate. The other thing I would say is, on the other side of the coin would be increased responsibility with stagnant reimbursement or payment. So, there's an explosion of tumor boards. Laboratory testing is becoming more complex all the time with precision diagnostics. And some hospitals also have outreach laboratories that serve the community and they wish to grow those. And so some of that responsibility goes to the pathology group or the laboratory director. That's not always recognized in the value of the arrangement. So those would be my thoughts there.
Liz, I would totally agree. I mean, I think those are all common issues that we see in our pain points, right, for the downward pressure. And just, and to the point about the Medicare Part A, and those payments and what that ends up being translated into as a medical director, I think in a corollary is Part B payments, right? Or commercial payers, right? Is the hospital going to pay when you're not billing Part A, you're doing those outreach services for Part B, or you're billing the commercial payers? Is the pathology group going to bill for those services to commercial payers, right? For those kind of the medical oversight, and give, disclosures to patients, or is that going to be billed to the hospital? Is the hospital going to reimburse? Or is there this kind of expectation that it's going to be free because they're doing it, and compensated under Medicare Part A? And I think that one becomes really sticky, as a discussion point, and then I think you make a good point as they branch into all of these other issues. It's that quality and the oversight and the other expectations and what's included. And with a lot of the pathology agreements, um, I think some of them are really old, right? Like hospitals and these pathology groups just have really old contracts that were not as defined. And so when hospitals and pathology groups are now renegotiating, it's also trying to memorialize what is the expectation and really outlining what are the services, what's included, and what should be paid, and how that, fair market value is determined.
Yeah, that's such a great point. You're right. When we were talking about this, we were talking about how we've all seen those contracts with hospitals that maybe are decades old, that, the parties just tried their best to continue to live and operate under them, and they they have not been appropriately updated.
Okay, well, let's move on to TC-PC arrangements. They're everywhere in pathology and getting a lot more scrutiny. What should groups and their counsel be watching out for when they structure these? And what's maybe a one red flag question to ask before agreeing to a purchase TC or global billing setup? Lisa, can you start us off?
Sure. So OIG has a process for requesting advisory opinions, and you can ask OIG to opine on a proposed arrangement and whether or not it would violate the kickback statute. And I think advisory opinion number 2306 is really instructive here. In that case, the requester, the one who went to OIG for the opinion, was a national anatomic pathology lab. And they asked HHS OIG whether they could enter into an arrangement to purchase the technical component of a pathology service from another lab, and then bill commercial payers for both the technical and the professional component of the laboratory test. What's important is that this arrangement included a carve-out, meaning it was really only limited to commercial insurance business, not Medicare or Medicaid. And the participants would be paying fair market value for the specimen from when they purchased. The lab would be paying fair market value for the technical component that they were purchasing from the referring labs. OIG here issued an unfavorable advisory opinion, and they didn't approve it for a couple different reasons that I think are instructive and things for you to think about as you're structuring these agreements. The first is that even though this arrangement was only for commercial insurance programs, OIG explained that carving out federal healthcare programs is not enough because payments were still tied to services from patients in a position to referral federal healthcare program business. And that alone can implicate the anti-kickback statute, and that's been the OIG's longstanding opinion there. The second issue is that OIG was concerned about the remuneration, and here it was a per specimen payment, that it could influence referrals of pathology work that may be reimbursable by federal healthcare programs despite the carve-out. And finally, OIG found that the arrangement really lacked commercial reasonableness for a business purpose. And in this case, it would have actually been better and more efficient for the requester to just do both the professional and the technical component. And that for that reason, because it wasn't commercially reasonable in OIG's opinion, they determined that it could be designed to induce referrals. And I think, the real practical takeaway here is that pathology labs and referral sources really need to be cautious with purchased services or split billing arrangements. Even if it's limited to commercial payers, that doesn't get you out of the kickback realm, because OIG may view them as potential kickback violations if there's any incentive tied to those referrals of federal healthcare program business.
I wonder, just to jump in, Danielle, I don't I know that you have seen these as well, and I'm not sure if you want to talk a little bit about typical TCPC arrangements, because Lisa, you've kind of set the stage for us. And certainly with pathology groups that are approached by referring physician groups, some of those referring physician groups will set up their own TC processing lab so that they can prepare their own specimen slides. And that is a lot of where I would say I certainly am seeing the challenge with these split bill or just TCPC arrangements in many different permutations. But typically we're talking with TCPC arrangements, they could be also with hospitals, but many of them, and certainly the way I read the advisory opinion, it is probably a referring group's lab and a typical more robust pathology lab or clinical lab that can do that work. And so what, reading between the lines, a lot of times what will happen is if the referring group is unable to bill for their technical component processing that they're doing in their lab, or they're getting less favorable reimbursement, they might go to, their partner lab and say, you have better reimbursement rates. Why don't you purchase this piece from me? And you could do the other piece. And so that's kind of a practical way that this is out there in the world. And oftentimes they're presented in a way that you sort of say, well, this could make sense. But you really want to dig down into that and sort of see where are the drivers and where are the financial incentives. So
Liz, I think you hit it on the head. I mean, I always ask, would this arrangement exist if other referrals were taken off the table, right?
Yeah.
Like, does it make sense? And I
Yeah.
think that really goes to the commercial reasonable point, which I think
Absolutely.
people often like overlook, right? It's part of the safe harbor for personal service management under the anti-kickback statute. But I think it's the one that often gets least focused on, right? Everyone talks about fair market value and they think it kind of ends there. Well, if I just pay a fair market value price for this, then it's all okay and we have a contract and it'll be fine. And it fails to look at that next prong of like, well, why is this arrangement existing? Is it because you're getting a favorable reimbursement, or you haven't gotten the in-network contract, so you're not getting paid? Like, what is the reason for it? I think also you have to ask, sometimes TCPCs can still be okay even with this advisory opinion if, you know, there's like some esoteric or niche, right, professional component where you really need that expertise from the pathologist. And maybe it does make sense for the patients to have a global bill, right? If everyone's in network, for example, and you have those. And I think, Lisa, you hit on part of the advisory opinion that really stuck out to me, in addition to the commercial reasonableness, is that it was less cost efficient and, inefficient to do this arrangement. And that line in there, it just stuck. I mean, I think everyone, when we saw these opinions and we're practicing in the space, said it's almost as if they were asking for a negative opinion, right? Because who would write saying it's, less cost efficient to do this? And I think that's part of it, right? Because that obviously goes to it. It lends itself to, the kind of the four principles that I think advisory opinions are written around about. Is it improper utilization? Is there improper steering? Is there unfair competition? Like, what is the bigger point? And so I think you really do have to dive down into those details in the arrangement and ask the hard questions about, why does this make sense outside of the money flowing?
Yeah, I would agree.
Any other comments here?
I just want to jump in and say, that's what the government does when they're investigating a kickback case. Like, that's the first thing is like, what makes sense here and why are the parties doing that? And so it's really important that you're engaging, I think, in those conversations with your lawyer, because at some point, if there is any type of an investigation, that's, a really common question of what is really the intent behind this, because it's very rare that people will say out loud or in an email that they're doing it to induce the referral federal healthcare programs, though it does happen. But so really the government's just trying to look at like, does this make sense, and what's the real intent behind the arrangement?
Okay, thanks. All right, well, let's talk about transactions. Acquisitions and pathology are growing, and as those grow, so do the compliance risk. Valuation decisions can start looking like remuneration if they're not grounded in F&V and commercial reasonableness. So where's the line between valuation and inducement? And for groups that are in a roll-up, where's the risk of getting pulled into someone else's compliance problem? Liz, can you take it?
Oh, sure. Yeah, I mean, I think this really builds on the commercial reasonableness discussion that Danielle and Lisa were highlighting in the last fact pattern because, but for referrals, why does an arrangement make sense? Or why does the pricing here, when we're talking about an acquisition, why does it make sense? And so, to your question, Don, where can you kind of get sideways with these? What I would say is, at least for a pathology group, it's most likely going to be in a situation where they're like being added to a multi-specialty group or, some type of specialty group that's more of um, a referring specialty, if you're thinking about a GI group that needs to add a lab or some other type of specialty like that, derm, urology, because in those instances, it's super critical that you're integrating the lab services and that the compensation across the group is consistent with the Stark law. Because if it's not, or it's, I would say for Stark, I'm thinking about it first from the Stark perspective. Uh, if that compensation isn't structured appropriately for the DHS, which is, the interpretation, the lab services, then the whole model could have an issue or could be under scrutiny. And then with respect to AKS, I would say it does come up. We've certainly seen settlements with the government for acquisitions of referring practices that are going into, a larger multi-specialty or that have the ability to perform pathology services. If the valuation for the acquisition of that referring group really isn't based in the referring group's productivity, then the question, if that is not clearly documented, the question or the inference is sort of, Lisa, what you were saying, which is, why is it being purchased for X purchase price if it's not about the productivity or the footprint of that particular group? Is it about, the potential for referrals? And so here we're talking about pathology, but it could be other ancillaries depending on the specialty. And so certainly there have been those settlement agreements. In one particular settlement agreement a couple years ago, there was a roll-up in which it was self-disclosed, and the allegation was that the organization had recognized through, probably internal documentation that some of the leadership had increased or agreed to increase purchase prices for certain of the target physician groups that they were acquiring, and it was likely because those physician groups were going to generate referrals. And so that was obviously problematic. And, when the government worked through the settlement agreement or the self-referral process and the settlement with them, they recognized that that was problematic. So I would say, those are two ways that you can see it in an acquisition, but I welcome the thoughts of the other panelists.
Yeah, I mean, I think that, acquisitions can be tricky. I mean, at some point, right, all the valuation of an acquisition is based on the business that entity is bringing in, right? So it is based on referrals kind of at the heart of it, anytime you're purchasing it. But the question is, just where does that become an issue, right? And I think sometimes it's that post acquisition when the owner stays on, right? And whether it's incentivized or whether it's if there's some other manner in which, as they're aligning into kind of the practice groups like you talked about, Liz, that that alignment has an increased expectation, right, of certain referrals being directed a certain way. And I think that goes back to those, kind of those themes that I think OIG looks at, if, as laid out in the advisory opinions often, is whether, is there inappropriate steering? Are we thinking about where referrals are going based on the best interest of the patient or most cost efficient or things of that nature? Or is it increasing utilization? And if those post-acquisition expectations, right, and being compensated for that is to improperly steer that or influence that, then I think that can be can highlight some concerns. And I do think this decision was interesting in that there was some sort of documentation about essentially purchase price manipulation, um, and how that played out.
Yeah, that's actually a really good point, Danielle. I was kind of focused on the purchase price piece, but you're so right that, it's kind of post-close and it's like, what are the compensation incentives for, the former owners or the former physicians as they come in to the group? Like, what's driving that? It's a really good point.
Lisa, do you have anything on this too?
I was just going to talk about self-disclosures, if you want to jump into that piece of
Oh,
it.
yeah, absolutely.
Yeah, I mean, I just wanted to highlight really quickly, because you mentioned that one of those cases was a self-disclosure, and I think now that I sit on this side, I realize how many. This is a complicated analysis, right? On whether you've discovered a billing error, so now what, right? And sometimes the right answer is that you just need to repay an overpayment. Sometimes the answer is you need to do a self-disclosure. Then who do you self-disclose to? Do you go to OIG? Do you go to the Department of Justice? And there's a lot of factors, I think, that go into this. But I guess the point I want to make is that there are a lot of benefits to self-disclosure when it makes sense. For putting on my government hat, the government knows that no provider is going to be perfect. And so the question is, when you have a problem, what do you do with it, right? And I think that at least from OIG's perspective, in my experience, they use a lower multiplier. They don't have compliance obligations, in part to encourage people to take the time to do the self-auditing and to identify problems and to be a good corporate citizen once they determine that there is an issue, and then bring it to the government's attention. And like I said, it gets really complicated. Is the rule clear? Should the payment go back? There's a lot of things that go into it, but I just want to say that you really interface with the government one in two ways, and one is when the government knocks on your door, and the other is when you knock on theirs. In my experience, it's always best to be doing the person who's doing the knocking. So that's my pitch for self-disclosure when it's appropriate.
I think, that's a really good point, Lisa. And I do think, you definitely get more favorable, cooperation, if you're being fully transparent and cooperative. I think that's always part of it, right? And it's always a hard analysis when we walk clients through whether, this is a self-disclosure or whether it's just an overpayment or what that is. I did think there was a case a few years ago that was also a self-disclosure, and it was after the TCPC advisory opinion. And a pathology group went in and did a self-disclosure because they had these TCPC agreements and they did an internal investigation. And, they had to pay a significant amount of money back because of, their conduct. But in the press release, it really highlighted that the self-disclosure and the full cooperation that the pathology laboratory presented the government with really reduced and saved them hundreds of thousands of dollars, I think was what the quote was, because they had gone through the self-disclosure. So I think that just really highlights, regardless of the type of scenario we're talking here, it's important to discuss that because no one's perfect. You may not realize. And it's important to have those conversations and go through that analysis as you just talked about.
Yeah.
Well, yeah, it sounds like what you're saying is self-disclosure could actually be part of a strategy, right, for counsel? Like, think about it as another avenue to make sure everyone's safe.
Yeah, I mean, Don, I think, all of us, as we advise clients, we have to sit there and say, both what do we have to do about looking back, right? When a client comes and we say, oh, there might be a problem here, it's not only about fixing it for the future, but is there anything we have to do in the back? And that can look like a potential self-disclosure, an overpayment, or maybe nothing, right? Depending on what, it is and where they come to us at the time.
Yeah, and I think this is such a valuable discussion because so often it is a tough conversation, like you said, Danielle. And I don't think providers always realize, that the government understands that everything's not always perfect. I think that there is a lot of hesitation and fear around the idea of a self-disclosure. But, as you guys said, there can be such significant value to it. It's really important to be a strategy as you approach, issues when they're uncovered.
Okay, well, we've covered quite a bit today. We've talked about service agreements, TC/PC structures, transactions, valuation, inducement risk, and self-disclosure. And even though these arrangements look very different on the surface, the compliance themes running through them are remarkably consistent. So before we close, how about one final question for everyone? If pathology counsel listening today could walk away with just one structural principle to apply across all of their arrangements, what should it be? Somebody want to just start that off for us?
Sure. I mean, I think you have to not look at things in a silo, right? Like you really need to evaluate the entirety of the strategy, not just one deal, one arrangement. And it's risk isn't just what about you pay. I think, Lisa started off really well saying, it's the anti-kickback statute has breadth, right? And I think as Liz and Lisa and I've talked about it through the day, you can hear that in all of the different ways. And so, it's not just what is the payment, but what can you expect in return? And really looking and asking the hard questions about the overall arrangement.
I think my advice would be invest in your compliance program. I mean, it is the front line. It is your first defense against fraud and abuse risks. And in my experience, we talked a little bit earlier about some of these really old agreements, that pathologists have with hospitals. And sometimes, a relationship, an agreement is perfectly fine when it's originally structured with the intent of the parties and the way that it's set up. But things change and evolve over time. And so I think it's important to just be doing that quick check on, does this still make sense? Or have in practice or intent, have things changed such that we need to take a closer look at this? Because, I think a lot of people, and, through my career, I've had a lot of people say that, they didn't commit fraud because they didn't know, right? It wasn't knowing, it wasn't on purpose. It wasn't this intentional thing that was done without recognizing that that's not what the law requires, right? I mean, the standard, it's more than negligence, but it's knew or should have known, right? And so the government's going to take this perspective of, we expect you to be taking a look at things. It's not that actual knowledge. And so I just really think that investing in compliance and doing a quick compliance review and just making sure that everything is on track, having really good internal auditing just serves you really well.
Yeah, I couldn't agree more. I would say my thoughts are, you guys have expressed them. Like every arrangement should be thoughtfully, it doesn't have to be sort of turn it inside out and upside down, but it should be thoughtfully considered. Like, what are the financial drivers? Where is the business flowing from? Who are the parties? It really is that holistic approach that Danielle said or talked about. And Lisa, absolutely, a culture of compliance. We're going to look at these. We're not just going to throw them in a drawer and let them collect dust. So.
Okay, great. Well, I think that's going to be a wrap for today's episode. A huge thank you to everyone on the panel here, Liz, Danielle, Lisa. Thank you so much for bringing such sharp, practical insight to the conversation, from deal dynamics to valuation pitfalls, compliance traps, anything that can sneak up on pathology groups. And thanks to our AHLA listeners. Thanks for spending part of your day with us. And we hope this episode gave you a clearer, more actionable view of the issues shaping pathology arrangements right now. Thanks for tuning in and have a great rest of your day.